Good. Yeah. So Raima to start. I will stop her and ask Victor to take over. I will stop him and also ask Salami Olamide to wrap up. Okay.
Okay, so yesterday we spoke about personal income tax, but more specifically, the administration of the personal income tax. And we were taught that the administration of the personal income tax is split into four. So we have the direct assessment, which is for trade or businesses. We have pay as you earn for employees, withholding tax for investors, and presumptive tax for the informal sector. Then we very specifically went into the administration of the direct assessment of the PITA. So basically, you just explained how the PITA doesn't specifically um, employ the terms direct assessments, but it's just a mode of taxation on persons carrying out trade or businesses, and it is employed in practice. So this has to do with the process of taxing the income of self-employed people. And then we went through the different stages of how the direct assessment administration works. So we spoke about the assessment stage. We spoke about how every single tax authority is supposed to have an assessment list according to section 56 sub 2. And then we spoke about cases. The case you mentioned was JB Daudu versus FIRS. And then the next stage was how to um determining of global income. Then we spoke about determining aggregate income from trade, what are badges of trade, the certain people that we can also tax, like bettors, gamblers, and sex workers. We spoke about how the next step is also um income exempted. So for self-employed people, how specific income is exempted from being taxed. Then we went further on to talk about deductible expenses. So we mentioned the rent test about um for every running of a business or any
Yes.
for running of a business, um there are certain expenses that count to the running of the business, so they are meant to be deducted. And the rent test states that any expenses which are wholly reasonably necessary to the running of the business is going to be deducted. And you mentioned the case of Sheila versus FPRR. And then we have the next stage, which is allowances. So allowances, certain allowances may be deducted the income to get the fully taxable income, such as capital allowances, losses, or consolidated tax rates. Then other like things like tax exempts, like the National Housing Fund contribution and National Health Insurance Scheme, and all of that. And then we went on to the minimum tax. And you mentioned about how after all the deductions have been made, or all the application of every other step, after the deduction of all the deductibles, the amount that is supposed to be taxed, which is the chargeable income, will be taxed according to um sorry, I'm trying to remember this section, but I think it's the sixth schedule of PITA, where we have the first 300,000 at 7%, next 300,000 at 11%, and so on from there. And yeah, when we have the minimum tax that is supposed to be charged, the next step is for the taxpayer to file a self assessment return. and after they have filed that, it gets reviewed by the tax authority.
Rahimat, can you pause at that stage?
Okay.
So that's brilliant. So thank you. Let's let somebody, Victor, you can take over from there. Victor, are you with us? Okay, Salami can take over.
All right, good afternoon, sir. Hello. Hello,
Go ahead.
Okay, so she stopped at the finding of self-assessment, that the part of the regulation is to do self-assessment. Self-assessment, I think it started in 1991. So they'll give you a form, then you fill out certain information stating your income and other details attributed to that. So this is self-assessment, and the aim of self-assessment is to aid and assist is to aid and assist that taxpayers pay their tax voluntarily, and also they have this, and it is expected that whatever they put in this self-assessment is true and accurate. So then upon filling the self-assessment, they will submit it to the board, that is the taxing authority, for review. So the board have the power to review the taxing review the self-assessment submitted to them, and either go ahead with it or decline the self-assessment submitted to them. So in the process of submitting the self-assessment to them, they will review it. So if they find that the assessments given by the taxpayer is low relative to what they perceive him to have, they can proceed with best of judgment. Their best of judgment. So the self-assessment authority, they have the limit of six years to tax people beforehand, because in personal income tax, particularly, taxation is done for the previous year, both contained in PITA and also in SITA, but particularly for PITA, it is tax for the previous year that is taxed at the present year. So it must be completed within 90 days. It must be completed within 90 days, or as the case may be, 90 days. So the next stage is object. If after the submission and the best of judgment has been given, and the taxpayer feels that there is a discrepancy between what is submitted and the best of judgment imposed on him, then he has the power to object that. So he will object it to the tax authority, and under the best of judgment authority, you gave us LIRS versus outsourcing. So he has the power to object, and the tax authority will give him a review of why they are giving him such best of judgment. If he's still not satisfied, then he can apply to the tax appeal tribunal. However, yesterday you noted that some state taxing authorities have refused to subject to tax appeal tribunal, because the tax appeal tribunal is an establishment by a federal statute, and they are state authority, which create a discrepancy. Then, however, appeal from tax appeal tribunal can proceed to the High Court, then from High Court to the Court of Appeal, then from Court of Appeal to the Supreme Court. So taxpayer, around that, sir. Thank you very much, sir. Sir, I'm done, sir.
All right. Olamide Salami, that was good. So the only comment is you have to improve your language, your choice of words. But I'm sure by the time you go back and familiarize yourself generally, that will improve with time. So that was brilliant. So do we have any other person? Okay. Now, you need to focus on the framework of Peter, the way I've highlighted it. And you need to focus on issues arising from different aspects. Because I highlighted some issues which I said should be of interest for those of you who want to write. Do we have someone who may want to speak to that? For example, when we were talking about residents, I raised the issue of Schedule 1. I raised the issue about Schedule 2 relating to settlement of properties, especially for unmarried children. Issues were raised, issues relating to pension. So would someone like to speak to all those very broadly? Or Class Governor Sheyi, did you keep a note for the various assignments I gave yesterday? Did you? Please, can you hear me? Hello?
We can hear you, sir.
Yes, sir, we can hear you, sir.
Okay, let somebody just give a rundown of the assignment I gave yesterday. Okay, Aisha Disu.
Yes, sir. Good afternoon, sir. Thank you, sir. Okay, so
Good afternoon.
some of the things I got, which are the possible areas of focus for the writing assignments, is that we're supposed to look at how we're supposed to look at it or just suppose it with what the current tax reform bills are proposing in that regard. But we're supposed to look at things like how the tax actors, so to say, can use technology to ensure that persons liable to tax are brought into the tax net. We're also supposed to look at how for instance, we should look at the issue whether income tax should even be centralized at all, as the present tax reform bills are proposing. We're also supposed to look to issues relating to the determination of residence, like you mentioned in Schedule 1 of Peter, vis-a-vis the issue of equity as to where they work versus their residence, and issues such as where a person has multiple areas of residence, like for instance, Dangote, whom you mentioned yesterday. We're supposed to consider that as well. We're also supposed to look at issues on trusts income, which you said was pretty tied. That the concept of trust is pretty tied into tax, and taxing settlements on unmarried children in Schedule 2, Part 1 and 2. We're also supposed to look at issues on income exempted in Schedule 3, as well as issues relating to capital allowance, capital expenditures, as the CAPEX and OPEX, with respect to direct assessments for persons who are self-employed or employers. Then the issues of double tax arrangements in Schedule 7, where I think what I got from that is where if person earns income in not just Nigeria but outside the country as well, or for instance, let's say in different states. Please correct me if I'm wrong, sir. And then we're also supposed to look at the structure of the personal. Okay, at the issue of the threshold with respect to personal income tax, that is, what's like the minimum threshold, and just suppose that with what happens in other countries, compared to what we have in Nigeria here, as well as the need for collaboration and why tax reform and why the present tax reform bills propose the Joint Tax Board. We're also supposed to look at issues with respect to what are the parameters of doing business and gaming, such as, for instance, like under the direct assessment, right? What would be considered business? And then give the example of Methodist Church against FBIR. That what would we consider doing as the parameters of doing trade exactly? Where, for instance, you have a church or a school claiming that, okay, because they're exempted, they're not doing business, they're just running their business. They're just running their activities according to how they do it. And since those establishments are ordinarily exempted under the respective tax laws, so they are not supposed to be charged or things like that. And you also mentioned the issue of gaming, that persons who are interested in gaming can also look into that. Also, we're supposed to look to things with issues with respect to badges of trade, for the determination of the parameters of what exactly constitutes trade, as well as we're supposed to look to issues such as how does the tax bill seek to make REN, that is deductible expenses, the REN test, how does it seek to make it more liberal as opposed to the, should I say, as stringent as it is now? I was writing very fast, so, but okay, we're also supposed to look at issues with respect to allowances that are allowed under PETA. We're also supposed to look to issues relating to assessments, things with respect to best of judgment, assessment levy. In particular, that I got was that, for instance, tax officials and how they use, this power that they have, for want of a better word, to terrorize taxpayers to ensure that like it's not supposed to be arbitral, right, or rather arbitrary, right? So that we should look to issues such as the requirement of non-arbitrariness. And then you mentioned the case of LIRS and outsourcing, I think was it outsourcing global. And then we're also supposed to look at the grounds upon which a taxpayer can object with respect to the tax assessment that has been levied upon them. And then we're also supposed to look at issues with respect to the notice of refusal to amend, that's NORA. Okay, finally, I think final point I got was issues with respect to the welfare system built into tax system. So just opposing what happens here in Nigeria compared to the welfare system and how organized it is in other countries, and how we can, and how tax actors can incorporate such lessons in Nigeria, having regard or looking also to what the tax reform bills are proposing. And I think the final thing also, though I think I've mentioned this before, is how the tax authority can utilize technology to have visibility on the income of individuals, so that even though, yes, the focus should be on the 20% controlling 80% of the national wealth or the wealth of the country, how then can it be done so that even those in the 20% controlling the 80% of the resources are still brought into the tax net so that they can pay the minimum dues that they are supposed to pay? That's all I got. Thank you, sir.
Yeah, that's wonderful. That's a brilliant attempt. So let's give Rahimat, Olamide, and Aisha a round of applause. So that was very good. So now you can see we covered a lot, and it's good for us to do that. At least that gives you some background to properly understand personal income tax. We are going to come back to some aspects, based on your deeper understanding. At that stage, you'll be talking like experts because you would have become one even without knowing. So we come to taxation of employment income. So I'm going to be fast because in this class, I want to cover the three other legs. So taxation of employment income. It's also an aspect of PETA. Preponderant majority of those who are paying personal income tax in Nigeria fall within this class, which is unfortunate, which the current tax reform is also trying to address. But does it mean that focus will no longer be on payee? No. As a matter of fact, there should be improvement of payee in order to ensure that leakages within the system are plugged. But at the same time, we have to go after those who fall within the 20% bracket. So the legal framework, Peter, is the first and the primary law, followed by Operation Pay As You Earn, which was made in year 2002. By who? By the Minister of Finance. And up till now, that law has not been reviewed. What does that suggest to you? Lack of seriousness. So even despite the fact that we have had law reform, the regulation has not been revised. It will be an embarrassment after this current reform, and we are still going to be using 2002 regulations. You must have heard that the withholding tax regulation has been abolished, has been replaced with a 2024 model or version. Okay? So the regulation has 23 paragraphs. Anybody who is interested in how payee work should focus more on that. 23 paragraphs where you are going to see all aspects of pay as you earn, beginning with registration to offenses and all that. So, personal income tax is an annual tax. Without a provision exempting what we have under payee, it would have been unlawful to ask someone who is not liable to pay tax until following year March to ask him to pay the first month of the year. The salary that I'm going to collect this month will suffer tax. But my colleagues who are in business will not pay tax on their income in January until March the following year. So you can begin to see advantages and disadvantages. Someone who wants to be an excellent student in this course must begin to compare and contrast. Okay, what are the distinctions between direct assessment and PAYE? What are the advantages and disadvantages? So class governor, start cropping some of these items so that when I call you next time, you can reel them out. Okay? So there is an exception. There is a provision in section 2.1 which provides that tax shall be paid for each year of assessment, and it defines year assessment to mean a period of 12 months. But section 26.2, Peter exempt income from employment from taxation on a preceding year basis. And this is the provision. It says with respect to income from employment or pension, which is derived or deemed to be derived from Nigeria, the assessable income of an individual shall be deemed to amount shall be the amount of the income of the year of assessment. So no preceding year basis. For the purpose of subsection 1 of this section, income from an employment shall be deemed to arise from day to day. So as far as PAYE is concerned, I'm like a wage earner. When you collect salary, you must pay tax on it. Okay? Then other substantive provisions you find in section 81 and 82. So all the provisions within Peter, the ones that are specifically directed to PAYE, they are not more than 3 or 4. And I've highlighted them above. So the basic question is, what is payee? What are the requirements for application. So there must be an employer-employee relationship before pay can kick in. If I get you to work for me as an independent contractor, PAYE will not apply. If you hire a lawyer to represent you in a matter and you are paying the lawyer, you cannot apply PAYE because the lawyer is not your employee. But if I employ lawyers in my firm and I pay them every month as I do, PAYE will apply. So what is the obligation of each stakeholder? Government has obligation, tax authority has obligation. Part of obligation of government is to make sure that we do not have a regulation made some 24 years ago. I was not born in 2002. I was still in my father's loins. So what will happen to this law? It will be outdated. It tells a lot of story about our attitude to subsidiary legislation. We focus only on the main statutes, relegating subsidiary legislation to the background, forgetting that there are multivarious sources of tax laws, including the Constitution. So when we are doing reform, we have to look at how the reform will implicate all the different sources. And not focus on just one, forgetting about the other. So how is the assessment done? Okay. How is tax deducted, remitted? Then how is audit conducted? If you are the tax authority and you ask Unilag, Yabatech, employers of labor, Dangote, Mobile, and everybody who has employees to collect tax on your behalf, you must go back to them and check their books. So tax audit is very, very important when it comes to PAYE. Then what are the issues arising? Now, PAYE is not a separate tax. If it were to be a separate tax, there will be PAYE Act or PAYE tax. So rather it is a form of administration of PIT, relating to those who are in employment and directing employer to withhold tax on behalf of government as an unpaid agent. So section 3(1)(b) is the focal point. It imposes tax on any annual salary, wages, fees, allowances, or other gains or profits from employment, including gratuities, compensation, bonuses, premiums, benefits, or other perquisites allowed, given, or granted to an employee. You notice that this is so wide. It's so wide that hardly will an employer pay anything to an employee without that payment being cut by this provision. So you need to focus on the meaning of each. What is a salary? I collect salary every month in this university. If I tell you, some of you will come to me and say, Prof, what are you still doing on this job? Salary is so small, but after my salary, I also have certain entitlements. Okay? Wages apply to those who collect salary, who collect payment on daily basis. And it applies to casual workers. Fees, I don't know how fees comes into employer-employee relations. Allowances, okay, I can understand. Leave allowance, leave bonus, medical allowance, and all that. So that is aside from the salary. Premiums. Don't know how premium comes into play here. I don't know how it comes into play. Then benefit, there are other benefits. For example, I have some other benefits within the university system, which may not make the entire package as bad as it seems. The salary may be poor, but there are other benefits. You have official car. Your children go to school and they don't pay the same amount as children from outside. You have a house. You don't have to buy fuel. The way my colleagues who come from Ibadan or who come from Badagry or Ikorodu. So there are benefits. In some other jobs, benefit can be as much as a house, a whole house. They just say, okay, keep it. It could be as much as a brand new car. There is an electric car that is trending on the internet now. When you Google the price, it's as much as the car is as much as 110 million naira. Oluwo, Dipo, you have the floor here. So Dipo, you have the floor.
Okay, good afternoon, sir. Sorry to disrupt you, sir.
No problem.
Okay, sir, I just wanted to ask a question, sir, regarding the houses. So let's say, for instance, an individual that is working in a multinational and he also gets, let's say they give him like a house allowance or something. Does that also fall under this category that you mentioned, sir?
Now, house allowance is a payment. So all payments will come in. For example, your salary is 1 million, but they give you house allowance of 2 million. Now, Dipo, if you were to be the tax authority, will you say, I will tax you only on 1 million and not 3 million?
No, sir, I would look at everything as one.
So if you don't tax the other benefit, what will happen?
If you don't tax the other benefit, that means that the tax authority will not be able to actually, they will not be able to remit.
No, they won't get enough. And what would the employer, what would the employer and the employees, what would they be doing going forward?
That means they'll probably be evading tax.
No, I want a specific answer. So who wants to intervene? Yes. Tiwalade.
They would be using that as a way to evade tax by putting more money under that allowance so that the amount that they are taxed is less.
Excellent. They will use it for tax avoidance purpose by now moving more money under allowance rather than salary. Some people will say, oh no, it's only basic salary that is taxed. That is a fallacy. Okay, everything, including parkusites. For example, if I always travel every year with my family abroad, the tax authority will find out how much is spent or is incurred on all those things and attribute them to me as salary. This is very interesting. You know, I'll give you some examples. Right now, I'm doing a case where an employer pays and is sent hire early. You know, once you are in certain sector, you know, it's as if you have employment for life because they can't retire you because of union. So the employer came up with incentive and said, look, our labor force is too much. We need to downside. They can say, if you have up to 5 years to go, but you choose to go now, we'll give you a lump sum payment. Pay a category of people that lump sum payment. So the question is this lump sum payment income taxable? Let's take it when a lot of you would have gained understanding into what I'm saying. Let me highlight another one. A company was giving silent proof generator to certain category of its staff. And they were also forgiving a housing loan, which they gave to some of his staff who have spent certain number of years. So if you fall in that category, they will buy a generator for you. Then silent proof generator was a collector's item. It was bespoke. It was new, you know. So it was a new technology. The tax authority got to know and asked the company to come and pay tax on them. We'll tell that story more fully. Then gave house loans to some employees under an obligation to pay back. And after some years, they say, oh, we'll write it off. So how is it treated under the tax law? So just bear in mind that this is very, very wide. Compensation, bonuses. You know, somebody has done well, you give him 13 months salary. 13 months salary is taxable. So please bear all this in mind. So I ask a question, does it apply to those who occupy political office? Those who occupy political office, are they in employment? That would be one of the issues arising. Then requirement for its application for an individual to be assessed to tax under PAYE scheme, it must be the holder, can you please mute, Akobi? It must be the holder of an office or employment, as opposed to carrying on trade, business, vocation, or practicing a profession. So it might be beneficial in many ways for an individual to be taxed as a businessman or professional rather than an employee. For instance, there are more opportunities for tax avoidance evasion as a businessman or professional than as an employee. The employer must be registered with the relevant tax authority. Why? Because you want to be collecting money on behalf of government. Government must know you. Agency relationship must be established. Without registering with the tax authority, collection of withholding of tax on behalf of government will be an offense, clearly. Okay? So Regulation 1 says 2.1 and 2, the employer shall within 6 months of commencement of business deduct tax. Why 6 months? As soon as you commence business and you employ, that is when your obligation should arise. That means once you start paying salary, you must deduct. So if you go by this, that means the law gives an employer 6 months to pay full salary to the staff without withholding tax. So because of this laxity, if you can do it for the first 6 months, you can as well continue because it's an habit that would have endured over a period of time. So how do you assess employment income? Before I go to this, let me refresh your memory on how you assess income from trade and business. Now, I have a firm where I incur lots of expenses to get going. There must be fuel. This morning or yesterday, a staff just told me that the laptop is bad. We have to change it or repair it. You know, you have to incur CapEx, you have to incur OpEx. So your assessment of somebody in trade is You bring together all your income from all sources and you take out your OPEX. If the OPEX that meet certain conditions before you come to your CAPEX under capital allowance. You know, like I said, they won't allow you to take everything in 1 year, but they will allow you to spread it for a period of time. You know, then there are other allowances, you know, loss relief, and so many other things that the law allows a trader or a businessman to deduct. But in the case of employee, as I'm an employee of the university, I don't have any CAPEX. I don't have any OPEX. This Zoom that we are using, I'm not the one who subscribed to it. You know, my office, everything in my office was provided for me. You know, if you are laid back, you just want to be an employee. But we are encouraging you to acquire the skill and develop the interest to be an entrepreneur, to build the largest law firm, not only in Nigeria, but even in Africa. If you cannot do it alone, bring together like-minders. When you travel for your masters, make friends across continent and say, look, enough of this magic circle firm. Let us plan in 10 years to beat them. And we are going to beat them by following a plan, okay? So computation of total income is the starting point. And here we have said everything will come in, you know, housing allowance. There's nothing, your overtime, basic salary. There was a time when I was still in Ife, during the ASU struggle, you know, an issue came up on the floor of the Congress. And they said, oh, they are even taxing us too much. That in tax, it is only basic. And then I was just beginning to be acclaimed as an expert in taxation. You know, then they said, oh, Mr. Sonny is here. Let him tell us. And I rose and I said, much as I would have wanted the law to be how they have stated it, I then referred them to this section. I said, it's everything, including even your benefits in kind, you know? So, of course, they didn't like my response, but because it was based on law, they said, okay, we will make it a political issue. Let them come and tax our houses. We will show them, you know? So the lesson from that is when ASU is negotiating, it should negotiate from knowledge that whatever the benefit will be, tax is going to take a larger chunk of it. So in developed countries where tax culture is very high, your concern is not how much are you going to be paid, but how much are you going to take home, especially in countries where the tax rate may be as high as 50%. Imagine you having a letter saying that your salary is now £100,000 or $100,000. But in reality, your take home is 49,000 pounds or dollars. So because of this realization, some people contract to collect net of taxes. Because especially expatriates who don't know your tax system, they don't know how it works, and they don't want to have any problem. So they just enter into contract with their employer that, look, my salary will be net of taxes. So that brings up the issue, whether that agreement is not contrary to public policy. So I want you to note it as one of the issues that will come to. So In addition to all that, there is also benefit in kind, which will be added to cash receipt. So the general provision for the treatment of benefit in kind you see in section 4. So section 4 covers an aspect, section 5 covers an aspect. So section 4 relates to assets apart from accommodation. I just told you that I have an official car. So where an employer provides an asset owned by the employer, apart from living accommodation, the employee is deemed to have earned an income equal to 5% of the cost of the asset or the market value at the time of acquisition. So my car now, they will look at the value and then they will say 5% of it every year will be attributed to me. My official car is almost 16 years old, so the value is not likely to be that much. So we are shopping for a new car for the dean and the sub-dean. So if you know somebody who can give us, maybe you know a car dealer who wants to do CSR, Depot, yeah. So which car dealer wants to do CSR for Faculty of Law?
Sorry, sir. So I wanted to ask a question, sir. So what of
Oh, you don't want to
where...
give the faculty, you don't want to give us a brand new car. So therefore, continue. Apparently, you didn't get my joke. Yeah.
Yeah, I got it, sir.
But ask your question. Yeah.
Because in whatever in a scenario where your car is being changed, like let's say on like in a 2-year or 4-year basis, because I know that there are some companies that they change cars of their employees, like 2 years, 4 years, like all those the top people. So how would they be able to like compute the assessment, sir?
Whatever your employer provides for you every year, in terms of asset, even if it's a phone, maybe there is a new phone, maybe a Fold 6 or iPhone 16 or 17. When your employer gives you all those things, they are called executive toys. So they monetize it, 5% of it every year will be deemed to be your income. Okay? So where the asset is hired, let's assume that they didn't buy it, they hire it. The cost of hire will be attributed to you. Okay? Now, the above provision will not apply to the following situation: provision of non-assignable luncheon voucher. If they give you sleep, go and eat in this every lunch, go to the staff club, go to a hotel, go and eat. But once they give you enough for you to give to your children, when we were in school, we have some colleagues whose parents will give them voucher. So anywhere they go, they can use it. So once it is assignable or the quantity is such that is beyond what one person can use, it will be deemed to be income and then taxable. Then provision of uniform, overall, or protective clothing, then removal expenses. You are moving from one branch to another and you need to move your family, or you are employed in Nigeria, you need to move from wherever you are to Nigeria or from Nigeria to elsewhere. That would not. Now, you need to pay attention to the provision of the statute. Look at the first one, where an employer provides an asset owned by the employer. I emphasize it for a purpose. In the scenario that I told you, that a company bought silent proof generator for its staff. This happened over 20 years ago. I was a consultant to the consultant who was fighting that case. So in the course of the argument, they initially said, no, they were not liable to pay tax. So later, the argument was that it is not the entire amount that will be liable to tax, it's just 5%. Then we argued that, look, you bought this for the employer. You did not buy it in your own name for yourself. If you have bought it in your name and you are, now the car that I'm using as an official car is not in my name. If it is in my name, the entire amount, will be taxable in my hands. So that is very, very important. And I want you to keep it in mind. So now, there is a special provision relating to property, which is not covered here, but I'll cover it by the time I'm giving you this. Now, the one relating to accommodation, the rate is the rateable value in that environment. So this is uncertain because rating of property is not very common in this part of the world, unlike other countries where you know the value of your house and you know what rate you are liable to pay on it. So some of these aspects, especially the aspect relating to PIK, is going to be simplified under the current tax reform. So you now come to, what we have been doing so far is to bring everything into the bucket, to aggregate. After you have aggregated, you now begin to deduct. So Raimat, I'll call you. You now begin to deduct. So there are some aspects that are not taxable. There are certain payments that are not taxable. Let's quickly go through them. Reimbursement of expenses. If I spend money on behalf of the faculty and I get reimbursed, that cannot be taxed as my income because it is not. It's cost recovery. I'm getting my money back. Medical or dental expenses. Okay, if I've incurred medical and dental expenses and then I'm being paid for it, is not taxable. Cost of passage to and from Nigeria, it is not taxable. Any sum paid in respect of maintenance of education of a child, provided that such an amount received by the employee will be deducted from the personal relief. That overlaps with certain relief, which you will see. Then any compensation for the loss of office. So Raimat, I'm going to call you, but I want to just point out some important things here. Now look at medical or dental expenses. In practice, company will pay certain lump sum to their staff as medical and dental expenses. And some people will tell them that, oh, they are tax exempt, that they are not. So a friend of mine, a consultant, had also tackled a company on the basis that, look, medical expenses are not taxable, but this is not medical expenses. This is an allowance. This is like a bonus. They say, look, if somebody has gone to deliver and incurred some money, that will be medical expenses. If somebody is sick or somebody has to do surgery, it will be made. All your staff cannot have the same type of sickness, cannot have the same type of medical treatment, and cannot incur the same type of money. So we're able to successfully argue that the amount is taxable. Then right now, these 5 and 6, on a matter relating to them. I told you that a company wanted to incentivize its staff to go early. So they pay some money to them, and they now call it gratuity. But our colleague who is tackling them say, look, when you pay in this circumstance, it's not gratuity. It's payment for loss of office. So payment for loss of office is liable to tax under CGT. It's not liable to tax under Peter. If you pay a lump sum for loss of office, even when it is exempted under Peter, which has a higher rate of marginal rate of 24%, it is not exempted under CETA. So the tax authority is now telling the taxpayer that, look, you have treated this payment wrongly. Number one, it is not gratuity, because gratuity has a mode of calculating it. Oh, it's based on the number of years you have spent, and is always in pursuance of collective agreement. But this one, the employer has said, I want you to go early. I'm encouraging you to go, Professor Sonny. We know you are supposed to retire at 70, but if you retire at 65, we'll pay you this amount of money. So we are arguing that that money is liable to tax under CGT. So let me stop here and then take Rahimat. Yeah, Rahimat Shitu.
Okay, sir. I just wanted to ask a quick question or clarification on the part of assets apart from living accommodation. You mentioned that when you use the example of like your company car, I just wanted to ask, since it is Unilag that is getting taxed and not you, because you're not the person that bought the car, your name is not on the documents for it. If by the time you are retiring or by the time you are leaving office and Unilag says take the car with you, so does the incidence of taxation fall on your part, or does Unilag still have to pay tax for that?
My battery drained out. Please give me a few minutes. Hello? So I'll be right back, please.
Oh, okay,
Right,
sir.
sir.
Thank you. Okay, sir.
Yeah. So I need to, so Raimat, can you ask your question?
Okay, so I was saying that regarding the assets apart from living allowances, like assets that are owned by the employer, the example you gave with the company car, if at the end of your employment, you know, like decides to the incidence of taxation fall on you or it still remains with you in lag?
I didn't get your question, please.
Okay, you know how when you're explaining assets apart from living accommodations, you mentioned the fact that stuff like cars they apply, right?
Yeah.
So my question was that because Unilag owns the car and they give it to you as an employee,
Yeah,
if
as
at the
part of
end
my
of
benefit.
as part of
Yeah.
your benefits, yes. If and you said that they pay tax on the car because they are the ones that bought it.
No, I'm the one who will pay tax on it. They will attribute 5% of the cost of that car as my yearly salary. So if my salary is 100, because they have given me a car, and if the value of that car is 100, my salary will now become 105 every year.
Oh.
Are you with me? So that is it.
Okay.
Yeah.
All right. Thank you, sir.
So if they give me a phone, they will attribute 5% of it yearly to be my salary. If they pay for my trip, round trip, myself, my family, everybody, and it costs them 10 million, they will add 10 million to my salary. Read one. So because we have we have lost time, I won't take any question after read one. Okay?
Okay, sir. Thank you, sir. Good afternoon,
Yeah.
sir. So my question in relation to the example that I gave, where you said the company gave the employers, the employees rather, silent generator. If they agree that the cost of generator will be deducted from the salary over a span of years, how would the tax be calculated in that sense?
No, that would be a loan to them. It's not a gift. If you bought it for them, and then you are recovering, the company is recovering the money back. That's not a gift. They are not collecting any dime from me for the car that I'm using. So the tax treatment is going to be that they'll just take it that the company has given them a loan to buy that thing, and then the benefits, maybe there is interest they are supposed to pay, which they have not paid, will now be attributed to them because they have gained. It's a kind of gain. something has been added on top of what they collect as salary. So all forms of benefits are taxable. So this is part of the area where accounting and the taxation diverge. So in accounting, nobody is going to refer to a house as income or a car as income. But taxation has deemed it to be income for tax avoidance purpose. So it's an anti-avoidance strategy or provision. So if you don't have Schedule 2, taxing trust income, everybody will set up trust. I will tell University of Lagos that give my money to a trust in favor of my children. And then the tax authority will get very little or nothing at the end of the day. So let me just quickly run through this. What lecture do you have after this class?
We don't have any class after this.
So I may overshoot my time a little. Just a little, you know.
Excuse me, sir. Please, some people
Yeah.
have environmental law.
Oh, beautiful. Okay, I will stop. I won't exceed my time then. Thank you for bringing that up. Okay, let me just quickly. Okay, so now we've already gone through allowances in the previous class. Those who are in employment, those who carry on trade and business, they are entitled to certain allowances. So everybody is. Currently, it is consolidated relief allowance, okay? Then exempted, tax exempt. If you have life insurance, this is one of the major tax planning avenue. So people hide, you are able to hide income through this, especially some kind of insurance premium, insurance that is like savings. So those who are high income earners, they take up insurance. So these are the old allowances. You know, what we have now is consolidated relief allowance of 200,000 or 1% of gross income, whichever is higher, or 20%, or 20% of gross income. But you know, that was kind of complex. And then in order to simplify it, look at the old allowances, personal allowance, very, very small, alimony allowance, children allowance, you know, disability allowance, you know, all manners of allowances, but the amounts were very, very small. So they aggregated all these together to now form the consolidated relief allowance. Then allowances, reliefs were not automatic. You must bring documents to support the fact that you are married, you have aged parents, you are entitled to, you have to prove it. But that's not what we have in practice. In practice, all employees is married, all employee has 4 children, all employee has aged parents. So the reform just assumed that, look, let's grant this across board so that we do not bother to check documents and then crowd the tax administration space, you know. And this has kind of been a big relief for all the documentations that were time consuming and all that. So this is the current rates. The first 300,000, 7%. The next 300, 11. Next 515. Next 519. Then next 1,621. Okay. Then anything above 3.2 million is 24. Then you must know how to calculate this. Minimum tax also kicks in. Of course, now, you know, the reform is proposing that minimum wage should be tax exempt. Then you have to object, you know, right to object. If an employee feels that he's being overtaxed, he can object. Then substantive provision makes the employer answerable. You know, and failure to withhold PAYE will render the employer liable to interest and penalty. Okay. So I think we must be. Okay, I still have about 2, 3. So there are issues arising. We'll discuss this during tutorials. Who is liable to administer PAYE? Majority of the people out there believe, oh, you must have 10 employees. That's a wooden lie. There is no such stipulation in the law. Then what is the role of employee? Employees have clear roles to play. They have to file assessment, but most employees don't. They don't even, some have never done it in their entire working life, including employees of tax authorities. So they just leave it for their finance department, who handles it on their behalf.
Sorry to interrupt you, sir.
What?
Yes, sir, please, I would like to bring to your notice that you are sharing a different material.
Oh, really?
I
Okay.
said I would like to bring to your notice that you are sharing a different material.
All right. Okay. Okay. I've noticed that. Okay. So I'll end in 2 minutes. Yeah. So who is liable? I've addressed that. Role of employees. I've addressed that. Role and obligation of employers. You know, some people have contended that employers cannot object, that the right person to object is each employee. And so there are conflicting decisions here. So my position is that if you audit an employer and serve employer with assessment, so that gives employer locus to employ, because you have not dragged each employee to court to recover the tax due. So you see conflicting decision there. Then failure to object within time stipulated will render the suit incompetent. Then BOJ is not applicable to PAYE. There are some decisions that suggest it. You cannot tax me on BOJ because being an employee, all my circumstances are supposed to be known to my employer, and then my employer is the one who is in control of my salary. So why should BOJ come in? Okay. So another issue is whether you can distrain employer in respect of non-remittance. You know, my position is that you can only distrain an individual who is a taxpayer because Section 104 of the law repeatedly, not less than 3-4 times, refer to taxpayer. And a corporate employer is not a taxpayer under Peter. The taxpayer is the individual. If my position in my writing is that, look, if Unilag fails to remit, they should sue Unilag to recover the tax, not just come to Unilag and lock our gate. So I think we should stop here. So in the next class, I will go back to some of these issues and then cover withholding tax and presumptive tax. So there won't be opportunity to take questions. So I will take your question in the next class in the interest of those who are going for another lecture. So apologies for the technical glitch. See you next week. Bye-bye.
Thank you, sir.
Thank you, bye, sir.
Thank you, sir.
Thank you, sir. Bye-bye, sir.
Thank you, sir.